Article 105 of the Constitution, and I read, a person who sits or votes in Parliament knowing or having reasonable grounds for knowing that he is not entitled to do so commits an offense and shall be liable on conviction to such penalty as shall be prescribed by or under an enactment of Parliament. Having done this, I have discharged my noble duty.
So that's the Clerk of Parliament, Ebenezer Ahoma Jetro, warning NSC Kumi in the wee hours of the 7th of January 2025 on the floor of Parliament before the swearing in of the Speaker and members of the 9th Parliament, following an injunction against him and his candidature as Member of Parliament elect for the Akwatia constituency due to the 7 December general elections. The NDC were challenging that result. They went to court to secure an injunction against his swearing in Parliament that was served on the clerk and the Member of Parliament elect at that time, but he refused. Today, the High Court in Akwatia, presided over by Justice Senyor Amedahe, which granted that injunction, has convicted NS Yao Kumi for contempt of court for defying that interim injunction which barred him from being sworn in as Member of Parliament. The court had earlier restrained the MP from presenting himself for swearing in, pending the resolution of the legal dispute which the NDC is in court for challenging his elections. However, despite this directive, Kumi proceeded to take the oath of office in Parliament as Member of Parliament. Let's listen to the Clerk of Parliament on that 7 January 2025.
The Clerk to Parliament was served a process on the 3rd of January 2025 with an order of interim injunction from a High Court in Akwatia. This order was served through the legal office of the Parliamentary Service. The order directed the respondents, including the Clerk to Parliament, indicating that they are restrained from proceeding to call, admit, register, swear in, recognize, gazette the said Ernest Yao Kumi as the elected member for the Akwatia constituency. At the time of the receipt of the order, the Parliamentary Service had already completed the process of registration of Ernest Yao Kumi as member-elect. Subsequently, there was a restraining order of a court. Since it is a court order, which order restrains the Clerk to Parliament as well from proceeding or dealing with a member in this matter, I find myself constrained. Honorable members, so I have brought this matter to the attention of the House. The member may decide, may elect to participate, but in doing so, I'm drawing attention to Article 105 of the Constitution, and I read, a person who sits or votes in Parliament knowing or having reasonable grounds for knowing that he is not entitled to do so commits an offense and shall be liable on conviction to such penalty as shall be prescribed by or under an enactment of Parliament. Having done this, I have discharged my noble duty. I'll end there.
So, you heard the Clerk of Parliament, Ebenezer Ahoma Jetro. Just after that, the Minority Leader, Apene Marking, speaking on behalf of NSC Kumi, noted that the latter was ready to bear any consequences of his actions, so he should be sworn in. Listen to excerpts of what transpired after that.
This is a house of rules and procedure that is not in doubt. This is a house that relies on precedence. I just have a simple answer, and I have the instructions of my respected colleague elect, Honorable Ernest Kumi. and fortified by the precedents of this House. Which precedents is dated 7th of January 2021. The member so desires to proceed to be sworn in and to also participate in the election of the speaker and bear the consequences himself.
Yes, the minority leader has spoken. He spoke for the member. Mr. Chairman, since the member elect is before this House, it will only be right for that member to speak for the records. If he's taking responsibility, let the records reflect that the member elect for Akwatia constituency has disregarded the court order and the repercussions of Article 105 of the Constitution applies.
I have taken note of what the Honorable Minority Leader has said. The Honorable Member heard what we said. He knows the consequences of his actions and inactions. So we leave it there. We will proceed.
So you have the Clerk of Parliament, Ebenezer Ahoma Jetro, ending except of what transpired on the floor on the 7th of January 2025. Today, the presiding judge issued a bench warrant for NSC Akumi's arrest after he failed to appear before the court for sentencing. Citing overwhelming evidence of willful defiance, the court ruled that the lawmaker had acted in contempt. Attempts by the minority caucus in Parliament to justify the absence of the member from the hearing through an official letter was dismissed by the judge, who maintained that Kumi had disregarded the court's authority. Listen to lawyer Bernard Bidiako.
Sometime last week, we moved to an application to have NSC Kumi convicted and sentenced to prison for his willful disobedience to the orders of a court of competent jurisdiction, that's the High Court of the Republic of Ghana. You would also recall that this case has been on since the 31st of December 2024, and the case essentially has been that NSC Kumi, that's a case that he was not validly elected. We followed up with a motion for interim injunction, which motion was granted for 10 days. Now, on the day that the NSC Kumi was served with the said order, he filed an application to have it set aside. Now, the court heard the application and on the 6th of January 2025 dismissed it, and thereby insisting that he should not hold himself out as the member of Parliament elect. He willfully disobeyed the orders of the court and went straight to Parliament and availed himself for him to be sworn in as member of Parliament. And he has since then been calling himself out as the member of Parliament. We decided then to petition the court as pursuant and consistent with the rules of court, which is under 50 of CI 47. Before the court gave his ruling, a lawyer, Gary Nimakun, was on his feet and wanted to be heard that he had filed some processes and thereby sought to stay the hands of the court from delivering his ruling. The court said, I don't recognize you. But I'm a bit surprised that Mr. Gary Nimakun would rise in open court in a contempt case, which we all know, we've all been trained and are aware that contempt proceedings are different from, because the standard of proof is even different. It has a different case number. And so what an NSC should have done was to either file an appearance or bring his lawyer to file an appearance. Or, because it's a quasi-criminal matter, like anybody who has gone to steal a sheep or a fowl, you have to be present in court to purge yourself of the contempt. You don't send a lawyer who has filed nothing. And you would recall that since the inception of this case, Mr. Gary Nimakun has always been coming to court, and he hasn't even filed an appearance consistent with Order 9 of CI 47. Indeed, all the ingredients in all the authorities he listed proved that he willfully disobeyed the orders of the court, and that irrespective of your opinion about an order of a court, it doesn't give you the license to disobey it until it is set aside. No court, as we speak, has set aside or did set aside the interim injunction, and so he was completely out of order to disobey the orders of the court. And so the court said that when that happens, the law is clear. You need to be convicted and sentenced. And so the court today convicted him. That is, the procedure is that, you see, the court cannot give his sentence in a vacuum. So the court at this point has found him guilty. Now, because he was not in court, the court now says that he now issues a bench warrant like any other criminal. And the police, the national security, should go after him wherever he is and be arrested and brought to him in court for him to be sentenced appropriately. So as we speak, by close of today, the security forces are going to be alerted that they should arrest Ernest Yaokumi and bring him to the court, the High Court of the Republic of Ghana, for his sentence. It is then that the court would pronounce his sentence on him. But at the moment, he is a convict. The court has duly convicted him.
That's the lawyer for the plaintiff, Bernard Bediakon. So what will be the sentence of Ernest Yaokumi? He could go to prison for 2 months, 2 weeks. He could apologize and he could be warned. That lies in the bosom of the judge. So we'll see what happens after the police have gone for him. Today he was in Parliament actually. Moments after the bench warrant was released, he spent barely a minute in the chamber. He went inside, picked his things and left Parliament. Let's talk about strike now.
This announcement goes to all CLAG members. As of today, CLAG has not received any official correspondence on the reassignment of Mr. Paul Adumboche, who was appointed Registrar of Births and Deaths Registry. Mr. Boche is still at post, performing official duties. The earlier notice of strike action on 20th February 2025 still stands. I repeat, the earlier notice of strike action on February 20th to 2025 still stands. All CLAG members should stay at home from tomorrow, Thursday 20th February 2025 till further notice. I repeat, all CLAG members should stay at home from tomorrow, Thursday 20th February 2025 until further notice. We need to take back our position as civil servants and not as a politician. Thank you.
If you are wondering how many people are supposed to stay at home from tomorrow, about 70,000 members of Civil and Local Government Staff Association are laying down their tools across all institutions in the country from tomorrow to begin the nationwide strike. The reason is government's decision to maintain Samuel Adumboche as Registrar of Births and Deaths. According to CLAG, the appointment of Samuel Adumboche as registrar violates a 2017 Supreme Court ruling on the neutrality of civil servants, which bars politicians from meddling in the administration of the service. The strike, according to CLAG, is to ensure that the Registrar of the Births and Deaths, Samuel Boche, is removed from office for being politically exposed. My colleague Zito Okwan just returned from CLAG's media briefing. She joins me in studio. Zita, what have they been telling you?
Well, Valentina, it's been a very long conversation or discussion with the Executive Secretary for CLAG, Dr. Isaac Bampo, where he still maintains the stance that CLAG would go ahead with the strike because it was a decision by NEC, and that since there has not been any response from NEC, then the decision still stands. That the statement that we saw earlier that we're going to go on a strike action on the 20th, which is tomorrow, still stands. But then he goes ahead to talk about the code of conduct. That's the article 195. Earlier, that the Supreme Court had ruled in favor of the Civil and Local Government Staff Association that if you are appointed to be at any of the civil servants department or institutions, you must not declare your political affiliation. Okay. And for this, they still say that Samuel Boche does not deem fit to be in that position because he came out clearly to declare his position as which party he belongs to.
Okay. So earlier, CLAG told us that they were going to hold on with the strike because they had received positive response from the government. Why did they shift from that position and now they are deciding to go on the nationwide strike tomorrow?
Well, he made mention, the Executive Secretary, Dr. Isaac Bampo, made mention that indeed they had engagements with the Chief of Staff with this particular appointment of the Registrar for the Birth and Death Registry, and they gave every paper that they had from the Supreme Court ruling in favor of them to the Chief Justice, the Chief of Staff, I beg your pardon, to have every court ruling that was said, because there were some other people who had the same position and for that reason they had been sacked. So they didn't want to have the decision that some people were favored and others were not, or others were sacked, and then all of these, they didn't want to be in the bad names of any, they want to be in the books of any bad names. So they decided that, okay, then they would, if they're being called, like just the Felix Kwachi mentioned, that they would have engagement with them. They are ready, but they will still go ahead with their strike despite any decision that, so far as Samuel Adumboche, still the registrar at the Birth and Death Registry.
So I want to find out whether he answered the question about they informing the National Labour Commission, because the labour laws is very clear. You can't just get up and go on a strike, declaring a strike barely 24 hours. You have to follow laid down process or procedure. Did he say whether they've written to the National Labour Commission?
Well, he didn't really confirm to me about the decision of or informing National Labour Commission. But then they still said that because NEC has decided, then that's it. 'Cause for that, he didn't even come out clearly to tell me that, okay, our strike stands. But he says it was a NEC decision, and until NEC responds, then the strike action holds.
Per the Constitution of Ghana, which, let me quote, 195. It says, subject to the provisions of this Constitution, the power to appoint persons to hold or act in office in the public services shall vest in the President. So the act of the President is not saying anything strange. That's what is in the Constitution. And it says it's in accordance with the councils. That's what is in the Constitution. What we are saying, we all know in Ghana who interprets the Constitution is the Supreme Court. We went to court that we cannot be denied in getting ourselves involved in politics. And the Supreme Court ruled. The Supreme Court ruled. So if you want to know, it's a Supreme Court ruling dated 2017. In the case of Local Government Staff Association in Ghana, we are the plaintiff versus the Attorney General, the Office of the Head of Civil Service, and then the Office of the Head of Local Government Service. This is the judgment, the ruling of the Supreme Court. Unless we are told that the Supreme Court ruling is not law. And let me quote the concluding remarks of the Supreme Court. Let me quote. The civil service and local government service are expected to remain in place, functioning in a professional manner to assure continuity and process integrity in the administration of the day-to-day governance. Visible partisanship and overt displays of lack of professional neutrality and objectivity would be a betrayal of the just expectations of the people of the Republic of Ghana, of the people of the Republic of Ghana. This is the Supreme Court. It says it's a betrayal of the people of the Republic of Ghana and the efficiency and effectiveness of these key government services. It is therefore our view, this is the Supreme Court ruling, it is therefore our view that the courts of conduct of the civil service and local government service in general do not deny civil and local government servants the freedom of association, particularly the right to join political parties of their choice. They mainly seek to place a limitation on the manifestation of that right while in service in order to maintain the neutrality of the civil and local government service and foster principles of anonymity and permanence. What they say in sum is, if you wish to broadcast or otherwise manifest your political party allegiance or run for political office, step away from these services. This is Supreme Court speaking. It says step away from these services. If you wish to broadcast, we all know that Mr. Botry is an NDC activist. He chose to broadcast it. He was a former DC of the Mensa administration. He chose to broadcast it. They said, if you wish to broadcast or otherwise manifest your political allegiance or run political office, step away from the services. This is Supreme Court talking. It's not Closak speaking or Isaac Bampado speaking. This is the Supreme Court. Now, our members have been dismissed for flouting this law. So, if we are saying, we are not saying the president hasn't got a right to appoint. The Supreme Court is saying anybody with political